And oh yeah, and I'll just hold up these when there's 3 minutes, 1 minute, and no time left.
Okay. May it please the court, my name is Nathaniel Simons, and I'm the counsel for the respondent. The issue here is whether or not Stephanie Wilder was unlawfully seized by Officer Placida when he approached her on a street corner 1 block away from her home. The court should affirm the district court's motion to suppress the evidence in question for 2 reasons. First, underneath the totality of circumstances test set forth in U.S. v. Weaver, Officer Placida never once unlawfully seized or stopped Stephanie Wilder in the entirety of their meeting. Secondly, by asking you to suppress the evidence, the appellant is asking you to allow criminals to walk freely among society and asking you to prevent police officers from ensuring public safety by taking adequate care of the communities in which they protect and live. The facts of our case are as such, where Officer Placida approached Stephanie Wilder on the street. He engaged her politely and calmly. He never accosted her or showed any authority whatsoever, which are factors set forth in the totality of circumstances test. She maintained her freedom to walk away during the entire time and move about the sidewalk as she pleased.
Counsel, would you argue that a reasonable person would just merely walk away from a police officer when the police officers retain their identification?
So what I would expect from a reasonable person, Your Honor, is that the reasonable person would understand that the voluntary giving of their ID would mean that they are not being detained, especially when they have done nothing wrong, in their opinion. Police retaining a citizen's identification is not dispositive by itself to constitute an unreasonable seizure, as set forth in Weaver. In fact, as set out by U.S. v. Carpenter, an 8th Circuit decision, when an identification is volunteered to an officer, that constitutes a voluntary consent for a 30 seconds computerized records check.
Okay, but this wasn't 30 seconds, was it?
This records check was not 30 seconds, it was 5 minutes. There is no evidence to indicate why it took so long, but I think that the time limit here is immaterial for the purposes that Officer Placida actually...
Why is that?
He wanted to run a computerized records check because he felt that it was a very suspicious situation in which a child was with 2 adults in a notoriously bad neighborhood with a tendency for high crime past
So does that mean you can just run warrants checks on everyone you see on the street in a high crime neighborhood?
Your Honor, I would not necessarily say that that is true. However, I would say that in situations like this, where there is a child with 2 adults past midnight out in a notoriously bad crime neighborhood, that perhaps after finding out a few facts that highlight what the person is doing, it is not so unreasonable as to ask for their identification.
But he had already found out what they were doing. He had found out that she had told him the right information, her name, her address, all of that stuff. And I'm having trouble understanding why someone being out with a child at midnight gives the police a right to stop and search people.
So I don't think that he was looking for anything in particular. I don't think he had any reasonable suspicion of crime. It might just be his police duty to go back into his car, especially if he does not demand, if he does not touch her, does not show his weapon, is very calm and polite, engages her with a respectful demeanor, that she might feel, or she probably did feel, that she was not in any way being detained, in any way unfree to leave. She did mention once or twice that she knew exactly what he was doing with the ID, and if she had had a problem with that in the first place, she could have mentioned it. Now,
Are you really going to mention that to a police officer? Like, hey, I know what you're doing, but I don't like it.
She did never once ask if she was allowed to not give the identification back to him. And I understand that Officer Placida did not mention that she could say no, but again, she did not ask if she did have to give him his ID or not.
Counsel, how would she have gotten her identification back had she just left in this situation?
So this was not an identification that was affording her any rights as set out in Royer, where the papers that the officers took were used to go on a flight. This identification was a state identification card. It was not a driver's license. She would not be unable to drive without this identification card, and she lived merely 1 block away. She at any point during the stop, she was able to walk that 1 block to her home, and if she felt that for any reason that having her ID removed for any certain amount of time, anytime within that 5 minutes, she could have asked any amount of questions, not just for the ID bag, but anything to the officer to see what he was doing with the ID for so
Would a
long.
reasonable person actually ask for their ID back?
I think that is up to a jury to decide, Your Honor. Another talking point is that the appellant will try to use State v. Daniel to emphasize how Ms. Wilder was seized by Officer Placida, but that case is bad law. Because in that case, the court maintained that the totality of circumstances in the test is imprecise, and that court chose to focus on singular details of the stop, which is why they concluded she had been seized. That court held that Daniel was effectively immobilized when the officer retained the ID, but however, I don't think that in our situation, Stephanie Wilder was ever effectively immobilized. Immobilization is defined as to make immobile, to turn immovable. And in that sense, Ms. Wilder was never made immobile, was never made immovable, and was free to walk the singular block to her home at any point during that stop. Thank you, Your Honors.
Thank you.